of action, require corrective measures, and use its authority to seek substantial civil penalties. Let me close by thanking our partners at the New York State Attorney General's Office, and I would like to thank in particular the FTC staff attorneys, Kristen Cohen, Tiffany George, and Peter McGee, for their tireless work on this case. Thank you, and I'd like to turn the podium now over to Andrew Smith, our Bureau Director. Thank you.
Thank you. So the floor is open for questions. I wanted to reiterate, while you're collecting yourselves for questions, that some of the points the chairman made. First, that this is the first time that we are holding a platform liable under COPPA for content on the platform. Second, this is an historic penalty. The chairman outlined that it's 30 times greater than our next highest COPPA penalty, more than 10 times all of the COPPA penalties cumulatively imposed to date, more than 3 times larger than the largest privacy penalty ever imposed on Google in any country by any regulator. I also wanted to note, it's a sort of a topic near and dear to my heart. It happens that $170 million is roughly the budget of the Bureau of Consumer Protection for 1 year. The agency budget is $300 million. $170 million of that is dedicated to us. So with this action, we are actually reimbursing the Treasury and the taxpayers for our operating expenses for this year. So no need for all of you to thank me now, but you're welcome. And maybe most importantly, that this action is changing YouTube's business model, that YouTube cannot bury its head in the sand. YouTube cannot pretend that it's not aware of the content on its platform and hope to escape liability for COPPA. YouTube is going to be explicitly held liable for complying with COPPA where it has actual knowledge of the content. YouTube is going to be required to seek out that actual knowledge through requiring content creators and channel owners to specifically designate whether they are directed to children. And as the chairman noted, not only can we sue Google and YouTube for compliance with COPPA, but also individual channel owners and content creators. And once this order has been fully implemented, we intend to conduct a sweep of the YouTube platform to determine whether there remains child-directed content on the platform with respect to which personally identifiable information continues to be collected. So, questions? Yes, Margaret. Oh, microphone.
Oh, thank you. Margaret McGill with Politico. Can you say what prompted this investigation?
Our investigation was prompted by complaints from consumer groups. No, Manisha? Oh, so we had started the investigation prior to that, and we also received complaints. I want to note that we appreciate our partnership with consumer advocates and privacy groups, and that we rely on the good work that they do to help us to enforce the law. Yes, question.
Hi, Ryan Tracy with the Wall Street Journal. This is another 3-2 vote following the 3-2 vote on Facebook. What, in your view, is the impact of having a partisan divide on a couple of these large settlements going forward?
So I hope that business does not doubt our resolve, that this is an historic penalty. It is staggeringly large in the privacy world and in the COPPA world. I am a little saddened, I have to say, by the partisan divide personally. I think this is a really strong settlement, and I think that it passes muster under anybody's standards. I also, however, appreciate the concerns of our 2 Democratic commissioners and the concerns voiced in that in their dissents. I would note that both of their dissents indicate that this is a thorough investigation conducted by staff, that the law violations are clear, and that the relief that we get is strong. It's just that they wish there was more of it. Yes, there's a question right in front here.
Thank you, Dave Pereira from AMLEX. You've referred multiple times to the sweep that the FTC will conduct on YouTube channels, and it's an important part of the enforcement of this order. Yet there are 23 million channels that upload a combined 500 hours of video every minute. So, given that amount of content, what kind of meaningful sweep can you conduct?
Well, I think that we have a variety of tools at our disposal to cull through those 23 million channels and in an expeditious way. I mean, this is the way that we generally enforce COPPA, is by actually reviewing content to determine if it's directed to children. We have a variety of factors in our rule that we consider when determining whether or not content is directed to children. And so that's the way we do business. It has been successful so far. I think that I have no doubt that it will be similarly successful with respect to YouTube, despite the large quantity of information on the platform.
Raquel Martin with Nexstar Media Group. Just concerned about the data that was collected, because obviously they're being fined for collecting some sort of data. What happens to that? Is it anything retroactively going to happen to destroy or remove that content from their possession?
Right. So under our order, YouTube is prohibited from using this already collected data for any purpose, even purposes that would be permitted under the COPPA rule. Yes. Margaret?
Commissioner Slaughter raised concerns that this would maybe incentivize content creators to misidentify programming to ensure that they continue to receive revenue from behavioral advertising. Can you respond to that criticism, and how might the FTC combat that issue?
So I think that's a valid concern. There is apparently, we've learned in this investigation and just learned from, in the now information in the public domain, that there are benefits to gathering information and targeting advertising. And so it is possible that content creators will misdesignate. So one response to that is that's why we're conducting the sweep. The second response to that is that there will be consequences for content creators who misdesignate, including being kicked off the YouTube platform. So if content creators are not sincere or forthcoming with YouTube and designating content as being directed to children, there will be consequences for them. We also think that YouTube has strong incentives to police its platform, both to avoid future enforcement actions by the FTC, but also because it's offering this platform to content creators. And if the FTC is bringing independent piecemeal actions against content creators for violating COPPA, that may discourage content creators from posting content on YouTube. So the analogy that I think of, imperfect, is the expression about shooting fish in a barrel. And YouTube is the barrel, and the content creators are the fish. And so it's a place where this content is centralized, and essentially it's easy for us to find. Yeah, up in front here, Mitch.
Okay, so the chairman talked about, I'm Diane Bars with Reuters. So the chairman was talking about how YouTube was not strictly directly liable, did I get that right? But the content creators are under COPPA. And you're talking about a sweep going forward. So does that mean that COPPA violations committed by maybe YouTube channels previous to today are not being looked at? Is that, or am I misunderstanding something?
Yeah, well, we're not saying that. I mean, there is no release in this order for other channel owners or content creators. Whether we are bringing actions against individual channel owners or content creators, I couldn't comment on here. I can't comment on any investigations that either that we have them open or that we don't have them open. So don't take that away from what the chairman said. I would say that with respect to strict liability, it's important to keep in mind what the COPPA rule does and what the COPPA rule doesn't do. So what COPPA does is it prohibits the collection of personally identifiable information from children under the age of 12 and under without verifiable parental consent. On the internet, though, you don't know who your users are. So what the COPPA rule more specifically does is where the content is directed to children, we are presuming that the users are 12 and under. So if you are the purveyor of child-directed content, we are presuming that your users are 12 and under and you cannot collect personally identifiable information from them without verifiable parental consent. If, however, you are a general audience platform like YouTube, you don't know what the content necessarily on your platform is. So we, under our rule and under the statute, you are only held liable if you have actual knowledge that the content is child-directed. So that's what we mean when we talk about strict liability for content creators, but a knowledge requirement for a general audience platform like YouTube.
Thank you for taking my second question. Another criticism of the settlement today has been an alleged double standard by the FTC, that it holds small COPPA violators individually liable for the COPPA violations, whereas YouTube, Google, big company, Silicon Valley, no individual executives have been held accountable in this order.
So I differ with that characterization of our COPPA enforcement to date. I do not believe that we treat small companies and big companies differently. With respect to an individual liability standard for a civil penalty, you have to show that an individual has actual knowledge of the violative conduct. That, as a practical matter, is much easier to do in a company with 2 employees than in a company with 200,000 employees. In addition, we typically seek individual liability where we need to fully protect consumers, whether it's to get money or to get an injunction that will actually be enforceable. And so in small companies, what you frequently find is that our concern is that the owner of the company, the principal of the company, will simply shut down and move across the street and do it again. So it's very important to get that individual under order. Also, you don't typically have those circumstances in a very large company. But I would say that with respect to the assessment of civil penalties, we have tried and I think succeeded in being even-handed. And that's why this is such an eye-popping number for Google. So what we typically do is we look at it. We look at the revenue that was earned from the violative conduct, and we apply a multiplier to that revenue based on the circumstances of the individual case in front of us. That's what we did in Musical.ly. That's what we've done in all of our other COPPA cases as well, at least the ones on my watch. So we have. So I think that we have something of a rubric for assessing civil penalties and individual liability under COPPA, and I believe that we have applied that rubric equally to small and to large companies.
Hey, Ben Brody from Bloomberg. You talked a lot about the knowledge requirement, and in the complaint, there's a lot of detail about YouTube basically touting its young users in its advertising materials. Given the steps that are going to be taken today, what could really prove that YouTube had actual knowledge of data being collected on child-directed content in the future, if this sweep maybe suggested that YouTube should be that YouTube is still collecting this data? Right. How could they really be held liable?
So the injunction is going to help because there will be a requirement that they actively inquire about whether or not content is child-directed of the content creators. Other than that, we have the same enforcement and investigative tools that we have always had under COPPA and that we used to prove up this case. So we have knowledge, we have evidence of actual knowledge of YouTube and Google that this was content that was directed to children. We proved that up with various statements which are highlighted in the complaint about, YouTube is the new Saturday morning television, and YouTube is the most popular site for children ages 2 to 12, that kind of stuff. So we will continue to have those tools at our disposal as well. But you're right that actual knowledge can be a tricky thing to show, and it can be very fact intensive. So in this case, if we were to have gone to litigation with this case, we would have had to prove actual knowledge with respect to every single channel and in order to obtain penalties for law violations with respect to that individual channel. Yet another reason why this is such a great number that the staff has been able to put up with this civil penalty. Okay.
So we're ready for questions from the phone, please.
Thank you, ladies and gentlemen. If you wish to ask a question, please press star one. Our first question comes from Tony Rahm with Washington Post. Please go ahead.
You there, Tony? Maybe he has us on mute.
We'll go to the next line. Joan Solzman from CNET. Please go ahead.
Yes, hello, can you hear me?
Yes.
Great, thank you for taking my question. I wanted to see if either the chairman or the director had seen the policy changes YouTube announced this morning and whether or not any of those go beyond what's included in the complaint and consent decree.
So I have not. This is Andrew Smith, the bureau director. Our chairman has had to leave for a meeting, but I have not seen the changes announced this morning by YouTube. I would say that over the last couple of months, there have been a variety of articles written about the changes that are being contemplated by YouTube. I would say that some of those are probably motivated by our order, and some of those are motivated by an interest in creating what I'll call a kid-safe zone, whether that be an app or a website where there is curated content for kids that parents can have confidence in. And it seems to me as though everyone, all of the stakeholders, the consumer advocates, the privacy groups, the parent advocates, the FTC, members of Congress, and industry would believe that the most beneficial end state would be general audience platforms hosting kid-safe zones where curated content can be provided and kids won't be subjected to violent or otherwise inappropriate content or advertisements or marketing. So I haven't seen this morning's changes, but I'm encouraged by them, and I do think that, at least in part, they may be motivated by our order and also by our investigation and inquiry. Oh, the changes are based on the order? Okay, so my staff has just said that she just took a look at the changes, and they are based on our order.
Thank you.
And our next question is from Tony Rahm with Washington Post.
Thanks, guys. Maybe this will work this time. I just want to follow up on something that a few others have asked at this point. I don't see anywhere in the order that explicitly requires Google to police YouTube to ensure that channel operators are appropriately labeling. And second, I can't tell if the commission ever sought to require Google to do that, to implement the kinds of machine learning tools that would do that active, constant policing. So can you talk about that and whether Google would be held liable in a case in which, a channel informed the company that it wasn't kid-directed content, but it turned out to be?
So if YouTube has actual knowledge that content is directed to children and it is collecting information about or from users of that content, then it will be liable. So that's just the rule. That's the black letter law. With respect to this idea that Google should have or should implement an algorithm or some sort of a classifier system for reviewing content and putting it in the child-directed bucket. That is something that that may be something that's among the changes announced by Google this morning. Is there anything in Google's announcement, Kristen, that discusses the algorithm? Because okay, so the announcement this morning says that the company intends to find child-directed content using machine learning. We thought about imposing that type of a requirement by order, but ultimately decided against it for at least two reasons. One is that it would be unenforceable, we thought, in an order. So what the order provision would say is, Google, you must implement a system, an algorithm, a classifier, machine learning in order to find child-directed content. Well, let's say that they did that, but we thought it was ineffective, or we thought it was, somehow sort of Mickey Mouse. And how would we enforce that in a court? Because we would say they implemented a classifier, but it didn't work. And the judge would say, well, okay, but how do I know it doesn't work? They'll have an expert who comes in who says, no, the classifier does this, that, and the other thing. And we'll have an expert that says the opposite, which is a classic sort of battle of experts, which courts hate in order enforcement proceedings. And there, we think that it may be that the tie would go to the runner, would go to YouTube. The second reason why we were concerned about it is that we didn't want that classifier to be used by YouTube as a shield against our enforcement. So right now the order says you must require all channel owners to designate if child-directed. Then there would be another requirement that says, and you must implement a classifier system to find all the stuff that's not properly designated. So YouTube does that. And then we go in and we try to enforce against them for an order violation or for a COPPA violation, and they say, well, wait a second. We did what you told us to do in this order. We're doing what no one else in the world has to do to comply with COPPA. And we were concerned that that would make it more difficult to bring an action in the future going forward. So those are two reasons why, and actually the third reason is that we thought that an algorithm just might not be effective, and it would be very difficult to prescribe a provision requiring an algorithm that could change with technology, change over time for an order that is going to be effective essentially until the end of time. So those are all the reasons why we thought that an algorithm wasn't a great idea in order. But I understand from this morning's announcement, as it was just relayed to me, that YouTube is undertaking that voluntarily. I think that is a demonstration that they have incentives to make sure to police their platform, not only to make sure that it's a safe place for kids, but also that it's a safe place for content creators. Because, like I said earlier, we don't think that they want to be in a situation where we are essentially using YouTube as a way to target our enforcement action against content creators and channel owners.
Thanks.
Our next question is from Anaya Kamenet with NPR. Please go ahead.
Hi, I'm wondering what differences might make in terms of user experience. Is it more likely that parents and children using YouTube will be prompted to sign in and get permission, or is it more likely that child-directed content simply will not collect cookies?
So user experience is something that we here at the FTC are quite concerned about. We're also concerned about the effect of this on the content creator community, and that's one reason why, one among many reasons why we have announced recently a review of the COPPA rule to look at this among several other issues under COPPA, not just the platform questions. So with respect to user experience, right now there is an app, and also as of a couple of days ago, I believe, a website for YouTube Kids, which probably mimics what a COPPA compliant user experience would be like. So there is curated content that is specifically targeted to different age groups of children. There is no information collected with respect to that, so that doesn't just mean no cookies and no targeted advertising. It means no comments, and also I'm looking at the staff no likes and favorites as well. So at the very least, no comments on so that would possibly detract from the user experience. Other than that, though, we have been told that the user experience is okay on those COPPA compliant websites. Now, will those websites continue to have the same quality and quantity of content? That's something that I think remains to be seen. Are there other questions on the phone? Oh,
if you wish to ask a question, please press *1. We do have a question from Kirk Victor with FTC Watch.
Hey, Andrew. Thanks for taking questions. Most of mine have been covered, but one recurring criticism is, how did you arrive at the penalty figures? That was a criticism both in Facebook and again on this. Can you elaborate a bit on how you came up with these numbers?
So, honestly, I would love to elaborate on how we came up with the numbers, but that information is non-public. It involves revenue figures from the various channels that we looked at. I will tell you that the number was revenue-based, and it was, as in our other recent COPPA cases, was a multiple of revenue. What we calculated to be the revenue earned from targeted advertising with respect to these channels. Now, keep in mind that YouTube could still serve up contextual advertising, so not targeted ads, and there would be some revenue earned from contextual advertising, and so we tried to not include that in the calculation. We also, keep in mind, would need to show that YouTube had actual knowledge that the content on these specific channels was directed to children. And I talked a bit about the challenges of showing actual knowledge, so that also was factored into our considerations. But given all of that, there was sizable revenue, and it's reflected in this sizable penalty.
Okay. Thank you.
Yes, there's a question right here in front.
Hi, Angelique Carson with the International Association of Privacy Professionals, the IAPP. The FTC has launched, I understand, its public consultation process on looking at COPPA and maybe revising the rule. I'm wondering what, if anything, this changes, or does this settlement influence perhaps the FTC's view on what should change under COPPA itself?
So, with respect to this rule review that we've announced, one of the topics that we will look at is whether there might be ways to encourage general audience platforms like YouTube to develop kid-safe zones with child-appropriate content and navigational tools. So that's just one of the topics. Another topic that we're looking at is EdTech, and whether we're looking at consent and parental consent as it relates to educational technology used in schools. So there might be all kinds of legitimate, important reasons to collect information in connection with EdTech in order to serve up the educational services. But how does one obtain parental consent, verifiable parental consent in that classroom context? Another issue that we are planning to look at is the collection and use of audio files, including our existing enforcement policy with respect to audio files that are collected. So what we have said in our enforcement policy is that a voice command, think about like an internet-connected toy, that a voice command can be collected in order to execute the command, but it has to be deleted as soon as practicable afterwards. So we would be looking at that, is that the right standard? And should, rather than just being a statement of our enforcement policy, should that also be incorporated into the rule? So the rule isn't only looking at these platform issues, but that is one of the questions that we want to review. And this brings me back sort of to the very first point, that the importance of this case for me, in addition to the historic penalty and the strong injunctive relief, is that we are holding a platform liable under COPPA for content posted by somebody else. That's a really big deal. And if you think about all the platforms out there in the world and the economic power that they wield and the amount of content that they host, this is game-changing.
2 more phone questions.
Okay. More questions from the phone?
We do have Kelsey Sutton with Adweek.
Hi, thank you for taking my question. I wanted to ask if you could walk me through what this sweep of YouTube conducted by the FTC is going to look like, when you anticipate to begin that sweep, what it's going to entail, and how long you sort of anticipate it's going to take.
So the order includes a period for implementation. So we would not start looking at, because it's going to take a while for YouTube to canvass all of its channel owners to determine, for them to obtain that self-designation of child-directed content. So there is a period of time during which YouTube has to comply with the order. Once that compliance period is completed, we would begin our sweep. With respect to the length of time, the number of sites reviewed, things like this, that is information that I don't think I can comment on. It would be non-public investigational information. But we do, looked at in context, we do a lot of these sweeps. Frequently, we conduct these sweeps in conjunction with law enforcement partners in states and elsewhere. And we recently did a sweep on robocalling that was announced earlier this summer. So sweeps are something that we do routinely, and it does take some period of time to develop an enforcement action. But I'm thinking we can do it relatively expeditiously. Are there other questions on the phone?
There's one final question. Joan Slothman with CNET.
Hi, yes. Thank you for taking another question from me. I actually wanted to ask a question also about the sweeps. There was language in describing them initially about how the FTC is prepared to take aggressive action or corrective measures should they find noncompliance. Can you characterize what sort of measures are on the table and what about them would be aggressive?
Well, with COPPA, COPPA is one of those few privacy rules that we enforce that has civil penalties. So when we talk about aggressiveness, we are typically talking about civil penalties. And again, I know that there may be some difference of opinion about this, but in my judgment, this is an eye-popping civil penalty. And again, it represents a multiple of the revenues realized from this practice. And so I think that we would have strong penalties in future cases against content creators and channel owners as well, particularly when we would have a situation where the channel owner was specifically asked, "Are you child-directed?" and the channel owner said no. So when we see those facts, we're going to have to evaluate them. Every case is different. We'll have to evaluate the facts that we are given, and we'll have to evaluate them in context. But if I'm a channel owner, those facts don't look so good for me, I think. Are there other questions? Yes.
Sure.
Margaret. Oh, we have two. Oh, we have two in the room, and then we'll.
Are there any?
There's no further questions here.
Okay.
Okay, thank you very much online.
Yeah.
Okay, Margaret McGill with Politico. I did want to ask, you mentioned with the rule review, a question of whether there may be ways to encourage a general audience platform to develop a kid-safe zone. I know some lawmakers had urged in the FTC settlement here that the agency require YouTube to move all kid-directed content to the YouTube Kids platform. Was that ever on the table? And if not, why not? Was that something under consideration?
So, we are encouraged by, I mean, we think that the recent announcements by YouTube to beef up YouTube Kids, but also to have the YouTube Kids platform not just live in an app, but on the website, that those are encouraging. And we are really encouraged by by platforms that are developing these kid-safe zones. I would say that from a COPPA perspective, from a privacy perspective, it doesn't matter whether the content is in YouTube Kids, on youtube.com or youtubekids.com or the YouTube general audience website. If it's child-directed and YouTube has actual knowledge, then it is, then they are going to be liable under COPPA. I also would say that there is a lot of content on YouTube Kids that is what's referred to as family-friendly, and it's not necessarily kids content. It's historical content or cooking shows or the I Have a Dream speech or the moon landing, or, you know, there are things that are kid-friendly that are sort of kid-ready that are not necessarily what we would think of as kid-oriented.
Hi, Ryan from the Wall Street Journal again. What is the status of the DOJ's filing